Well, thank you very much indeed. It's a great honour and privilege to be here. I realise this is a bit like walking into the lion's den. I'm a professor of law, and lawyers aren't very popular with economists, and dare I say it might be the same in reverse. But I'm just going to talk a little bit about the Trade and Cooperation Agreement as I see it from a legal perspective. Just before we get into the detail of the agreement, I thought it would be helpful for you just to see how we got to where we have, and specifically the UK implementing legislation to deliver on Brexit. So in summary, we negotiated to leave the EU, leading to the withdrawal agreement, that's the divorce text. And that was given effect into UK law, both by the EU Withdrawal Agreement Act 2018, by far the most important piece of legislation of this group. And that act has been amended by the 2020 Act, the EU Withdrawal Agreement Act, which amends the EU Withdrawal Act 2018 to give effect to the divorce text. We left the EU on the 31st of January, but we went into a transitional implementation period, which was broadly status quo, to give us time to negotiate the future trading relationship deal. And in the course of that, we also passed the Internal Market Act, which will raise all sorts of interesting and difficult issues in creating an internal market across the four nations of the United Kingdom. And as you know, on Christmas Eve, we did successfully conclude the Trade and Cooperation Agreement, and that Trade and Cooperation Agreement has been delivered into UK law through the EU Future Relationship Act 2020. So I'm going to talk to you about the TCA, the Trade and Cooperation Agreement, which is the text that was concluded on Christmas Eve. And the way it's structured is as follows. In good EU style, it is built around the sort of a building model with a common structure across the top and a common structure across the bottom. The common structure across the top is the institutional provisions of the agreement. The common structure across the bottom is the dispute settlement provisions, the common dispute settlement provisions. And wrapped up or sandwiched between those two bits of bread is the free trade agreement, which includes not just goods, but services, transport, social security, fisheries, and other matters. And then you've also got another pillar, a surprising pillar, in fact, on law enforcement and judicial cooperation in criminal matters. This is a much more sophisticated and detailed provision than had been expected. And then there are other bits of the treaty, which I won't mention in any detail, including the possibility of the UK having access to union programs like Horizon 2020. And then by far the largest part of the treaty is the section on annexes and protocols. So if you know, the text itself is about 1,400 pages. 400 of those contain those substantive elements I've been talking about. Annexes and protocols are the remaining chunk. And the annexes and protocols is where a lot of the detail is. And as always, the devil is there. A couple of points I want to draw to your attention. First of all, this treaty is drafted as a sort of baseline with a view that it can be improved upon. And there's lots of references to the fact that further bilateral agreements might be concluded. But crucially, they will all fit within this broader institutional architecture. Why does that matter? Because the EU does not want to have a relationship with the UK like it has with Switzerland. Switzerland has 120 or so bilateral agreements, and there is no overarching institutional framework that you have in respect of the TCA, which you've got in front of you. Next point to note is that this is very much an agreement of international law. It's bent over backwards to make sure it makes no reference to anything to do with EU law, and so no notions of direct effect or enforceability. Because this is an international agreement, it is a state-to-state style agreement. So it looks much like a free trade agreement that you have between the EU and Canada or the EU and Japan. It is not like EU law minus. It's quite the contrary. It is very much a free trade agreement. The other point to note is that there are lots of review clauses in the treaty, and crucially, the whole thing can be reviewed every 5 years. And of course, that 5-year timetable coincides with the UK election timetable. So there is every chance that this the content of this agreement will be subject to review and will become a manifesto commitment or not for the main parties. So anyone who thinks this is done and dusted is wrong. This issue is going to run and run and run. On the right-hand side of the diagram, you also see reference to some unilateral measures from the EU, one of which has already been concluded, which is the UK third country SPS listing, which has enabled our SPS standards to be considered sufficient that the EU will allow our goods into the EU, albeit subject to rigorous testing. There was no special concession made on that, as there is between the EU and New Zealand. There was no decision on adequacy, but of data protection, but that has been deferred, and so we're operating under the old rules. And as this audience knows very well, there has also been no decision on equivalence in financial services. So that's the broad structure: common provisions across the top, common provisions on dispute across the bottom, and those framing will apply to not just this treaty, but any other future agreement that is concluded. But because this agreement can be reviewed every 5 years, in my view, it means that this agreement is much less stable than you might expect, because of course it's subject to politics and what the main parties are going to fight over at the next election. Now, I don't want to dwell too much on this, but in fact, there were 3 agreements concluded on Christmas Eve. Clearly, this is the main agreement that was concluded, but there were 2 other agreements, one on security procedures for exchanging classified information and one on the safe, peaceful uses of nuclear energy. I'm not going to say anything more about that. What I do want to say something about is governance and dispute settlement, and that's the bit across the top and the bit across the bottom. Now, I simplify in this diagram, but what I want you to see is that the way the governance structure works is as follows. There is a partnership council which operates at the top of the tree, and that is a political body. For those of you who have been following anything about the withdrawal agreement, that's the divorce text, and the Northern Ireland Protocol in particular, there was a joint committee there. The Partnership Council does the same thing. The Joint Committee is presided over by the Vice President of the Commission, Sefcovic, and Michael Gove on the UK side. And they are due to meet at least once a year. You'd hope they might meet a bit more often than that. But most of the grunt work is done by a whole plethora of committees. The Trade Partnership Committee, specialised committees and working groups, summarised here for you. Anyone who thought they were leaving the EU because they thought that the governance process under EU law lacked transparency is in for a shock, because look at the opaque government structure that is set up under the TCA. Now, those committees are technical committees, presumably going to be staffed by civil servants. But the real question for the UK is how much scrutiny will Parliament, not just Westminster, but also in Edinburgh, Cardiff and Belfast, be able to scrutinise what's going on and have their say. There is a new body that's due to be set up, a Parliamentary Partnership Assembly, where the Parliament, namely presumably Westminster, will cooperate with the European Parliament. And there's also at least in theory, the participation of civil society. The question is whether these will be anything more than a talking shop, or whether they'll actually have some sort of important input function. These bodies, the Partnership Council and all of these committees and subcommittees, make decisions by mutual consent, because we are now moving to an intergovernmental model, not an EU model. And they can issue decisions which are legally binding and recommendations which are not. I also want to say something about dispute resolution, and then I will pause. So on dispute resolution, for those of you who are familiar with EU law, you'll recall the fact that under EU law, if I don't like what the French are up to, and the French are, for example, blocking my gin to get onto the French market, I can either go to the Commission and ask the Commission to intervene on my behalf, or I can bring a case in the French courts. All of that has been turned off to me. Instead, the dispute resolution mechanism looks much more like the dispute resolution mechanism in a free trade agreement, and with some similarities to the process under the WTO, the World Trade Organization, and its dispute settlement understanding. And in essence, the way it works is as follows. There's going to be consultations in the Partnership Council, and you remember the Partnership Council was that top level political body that I mentioned to you on the previous slide. And if those consultations don't deliver a solution, then the case can go to arbitration, and the arbitrators have up to 160 days to come up with a report. There's an interim report stage where the parties can comment. And then we move on to the compliance stage. Now, if the UK is the losing party, it can say, yes, we've got it wrong, we'll comply, and they've got a reasonable period to do so. If they do not comply, or they can agree compensation, that's relatively rare. And if not, we move into the world of temporary remedies. And temporary is anything but temporary. Temporary can be pretty permanent. And this is where you're in the world of retaliation and cross retaliation. So one side can impose tariffs on the other side. Those tariffs have got to be proportionate. They should be in the same economic sector, but if that doesn't work, you can have cross-sector retaliation. Now, the one thing I do want to say is that this is completely different to enforcement under EU law. It is done on a UK EU level. So the fact that I can't get my gin into France means I can't do anything about it personally. I'm going to have to lobby the UK government to intervene on my behalf. And if the UK government thinks, well, my business with a very small turnover is not worth worrying about, then I have nowhere else to go to try and fight my corner. So it's state to state or state to EU dispute resolution. The other thing to say is that usually in free trade agreements, actually the dispute resolution mechanisms aren't often invoked. And so that tends to suggest a lot of things get sorted out at the consultation phase. Now, it might be different between the UK and the EU, given the pretty bad blood that you're seeing on both sides at the moment. The other thing to note is if you look at the WTO dispute settlement understanding, there are about 600 or so cases that have been started since 1995. That contrasts with the 2,000 or so cases that the European Court of Justice hears every year. Now, in the DSU, the WTO agreement, what you see is that most cases get sorted out at the consultation phase. And those cases which go as far as compliance, there's only about 18 or so that have actually gone to the dramatic retaliation, cross retaliation stage. So what we don't know going forward is whether this procedure will really make a difference, or whether in fact it's honoured, it's there, but in fact most things are dealt with politically rather than through the arbitration panel. The final thing I'll say, because I think my time is about to run out, the final thing I'd say is that there's not just one dispute procedure, there are several. And crucially, for rebalancing and level playing field issues, those are the most controversial issues in the negotiations, there is a much shorter, dirtier procedure which will apply. And if that's invoked over free ports or over attempts to change employment law, then we're in for a pretty bumpy ride. Thank you very much indeed.